Yes.
Any mention?
Yes.
May I please, Your Lordship? There is in one urgent matter, Your Honor, Lordship, WPC, regarding tender. So if matter is prayed,
Regarding?
if matter is heard before the court.
Regarding
Tender, there is the urgency.
when tender against the tender NIT, when is the last date of tender, opening of tender?
No,
or
Lordship.
submission?
Actually, tender is already. Result is.
What you are challenging? You have come against the settlement made in the tender process, or you have come against the issuance of NIT or
technical evaluation. Technical evaluation. That is a mark sheet. After
that process has started.
Process has started, Lordship.
You have tomorrow, not today.
Lordship, there
You
is
file it
urgency. Work order may issue, Lordship, anytime. Work order may issue.
No, you say that technical bids, consideration of technical bids.
Yes.
So how can
Because-
work order be issued on the one day?
Lordship,
Have it tomorrow.
because I am the second qualifier, Lordship, and there is favorism for the respondent number 5, Lordship, and there is
Tomorrow. Not
Lordship,
file it today, tomorrow.
Lordship, if they humble prayer, Lordship, if it is not.
No. What is that? You say this tender has not been settled till now, isn't it?
Work order is not issued, but
So tomorrow, do it tomorrow.
but it is possibility that today work order may issue. Lordship, there is meeting is going on,
No,
Lordship.
you have come against the
Technical evaluation.
yes, and then
Lordship,
after
that is a
technical
mark.
evaluation, then there will be
Lordship,
technical bid, there will be financial bid, there will be many things, isn't it? The
Lordship,
financial bid is yet to be considered, so no work order can be issued in one day. That is the normal assumption. We do it tomorrow, not today. Yes.
Please, Your Lordship, I beg to mention from item number 9.
Item number 9.
Yes.
Yes.
In this case, Your Lordship, this is pending. The issue is still pending in the DV. So I pray to Your Lordship if you allow us to mention at the time when the division bench is already done, because this case is related to the consent. So when the case is already over from DV, then we will mention, and the same may be listed in.
No, we do not know. See, we will not give you. You want that it should be adjourned, Senada, you say, like something like that, isn't it?
Yes.
No, we'll have it after 3 weeks. We'll just see. Let us see what is the start. No problem. We'll have it after 3 weeks.
I'll oblige, Your Lordship.
At the request of yes.
I beg to mention item number 4 and 5. It's a similar matter pending before the Honorable Apex Court, and that it will have a direct bearing on this case.
Correct. Item number 4 and
4
5.
and 5, Lordship.
Okay. The under counsel hearing for the parties submit that the connected matter pending before the Apex Court having bearing in the present matter is yet to be disposed of. Step. Paragraph in view of the submission. This is matter after
4 weeks.
4 weeks. Yes.
Item number 6. I have not received any instructions from the bank, Your Lordship. So if I do not it may be adjourned for today. If till the next date I don't receive any instructions, then we can proceed with the hearing, Your Lordship.
That was for production of some.
Yes, records, Your Lordship.
No, but then if they do not produce it, then we can make the officer responsible. Anyway, give a try, then we'll bring it.
I have sent them letter. I've sent them a letter.
They're bound
also.
to, duty bound to.
Send them a
They cannot
letter.
refuse you. They
No,
are bound
I
by what
don't
we-
think. Let me see. They have to give me a
They are
reply.
bound by they are bound by your instruction.
Yes.
They cannot defy you once you.
Yes.
So
Either
assert
say
yourself.
they
assert
don't have the
yourself-
records, or they don't.
Assert yourself and tell them that if you do not do it, then
Court
serious
will-
consequences.
yes. Okay, that's right.
Who is the petitioner?
The petitioner is Manigdhar. Mr.
And then
Costa Paul is a.
you are standing on the other
Oh,
side.
I'm so sorry, Your Lordship.
Yes. You're objecting.
No objection, Your Lordship.
So when?
After 2 weeks, Your Lordship.
Okay, just say the request made on behalf of the respondent. The request made by MS T. Yangi, senior advocate. You are here, senior advocate.
Yes, Your Lordship.
Another further 2 weeks time is granted to obtain necessary instruction. As paid for by the so and so, and then not objected to by the so. Then you say further 2 weeks time is granted.
Oblige, Your Lordship.
Yes.
May it please your Lordship.
Yes.
Lordship, I beg to mention item number 11. Lordship, we are having some personal difficulties. We are praying if your Lordship will grant us 3 weeks time.
No objection, Your Lordship.
The request made by Mr. Abal Honored G. Preparing for the state respondents. So this is matter after 2 weeks.
3 weeks, Your
3
Lordship. 3 weeks.
All right.
And your
Similar prayer for item number 12, Your Lordship.
That was his player, and now item 12.
Item number 12, Your Lordship.
You are appearing for?
For the petition, Your Lordship. The conducting counsel have some personal difficulties, Your Lordship.
No.
no.
This also at the request of the petitioner. Disturbed for 2 weeks. Yes.
3 weeks, Your Lordship.
3 weeks.
3 weeks.
All right.
Oblige, Your Lordship.
Supplementary causes, item number 1.
Yes. Yes, please.
May it please your Lordship. Your Lordship, I'm moving this petition filed under section 528 of PNS Act 2023 for setting aside and quashing of the FIR dated 11/5/2022 and GR case number 71 of 2023, which charged under section 279, 337, 338, 427, and 304A of IPC, which is
Accident
charged.
case. Accident case.
Yes, Your Lordship.
Rash and negligent driving.
Yes, Your
Resulting in death of one person.
Lordship. Yes, Your Lordship.
Yes.
So, Your Lordship, here the petitioner number 1 is the alleged accused person, and the petitioner number 2, he is the complainant, Your Lordship.
Together.
Yes, Your Lordship.
Why together?
Your
What
Lordship,
is your prayer in this case? You are seeking what?
seeking for quashing, Your Lordship, the FIR and the GR case, which is pending before the
On the basis
Honorable
of?
Court of CJM.
Wait, what? On the basis of your
On the
seeking
basis because the both the petitioners, they have reached in amicable settlement, because the petitioner number 2, who is
Where is the settlement?
is a verbal settlement, Your Lordship, because the petitioner number 2, who is the complainant, he said there is no rash and negligence driving on the part of the petitioner number
No,
1.
it means there is no such
And
settlement. as
Your
such.
Lordship, he has stated, because the evidence of the petitioner number 2 has been recorded, Your Lordship, before the court of CJM.
Okay,
Your
matter is
Lordship.
charged
So,
now trial is going on.
yes, Your Lordship, and the
And then-
evidence of the petitioner number 2 has been done, Your Lordship, and he has clearly stated in his evidence before the court that he do not want to proceed, Your Lordship.
But that is okay. If he doesn't want to proceed, let the trial court take a call on that.
Your Lordship, but there
This
will
cannot be a ground for
uh,
interference of 482. Where is it? There is no other settlement other as such, like written agreement and all those things.
no, Your Lordship. He has
And
stated in his
then how do we decide the voluntaries? See, like,
Your Lordship, he has clearly stated in his evidence in page 33, Your Lordship. We have annexed his
Page?
deposition,
Page?
page 33. In page 35, annexure for your lordship.
Yes. Page 33, page 34.
In page 35, your lordship.
Dustin Masharing.
Yes, your
Dustin
lordship.
Masharing.
Yes, he is the brother of the deceased.
And he is a complainant in the case.
Yes, your lordship.
He is the brother of the deceased.
Yes, your
And the
lordship.
deceased is unmarried.
Yes, your lordship.
And deceased doesn't have his parents alive.
He had,
Then how come brother come and settle the matter?
because he is the complainant, your lordship.
But even then, yes.
Lordship, I'll accept notice on behalf of the state. My lord, so far as agreement, and my lord, there is no such agreement, only verbal submissions, my lord, that I have personally, like, we don't want to pursue with the matter. My lord, I've seen instructions, my lord, about the stage of the
No, but
case.
then why complainant and accused together has filed this petition together? If they are represented
They
by...
are, and
See, if
moreover,
they are,
your lordship,
see,
they
just
are
wait. If they are represented by one counsel, we will not know whether that decision to compromise is voluntary or not.
in
It's
the,
very difficult.
In fact, my lord, mother and the father, they want to make a party for regards to the agreement, my lord.
they are the relative, they are close relative, your lordship. They are cousin brother, maternal cousin brother.
See, you do not have any compromise in writing. You are relying on some statement made in the court during the course of trial. And then here the accused and the complainant,
Your lordship, here in
both are
page,
represented by one counsel.
I may be allowed to read this page 35, your lordship, his deposition before the
That is
court.
all that I have
because
seen.
it's
I have
on,
seen that. I have seen that.
Oath.
In his cross-examination, isn't it?
Yes.
But
In
that is
his
he did not.
in his in chief also, your lordship, he has stated that I can identify the accused person who is present in the court today. The driver was not driving the vehicle in a rash and negligent manner, and the accident occurred due to bad weather.
That is okay,
Yes,
but then
yes.
it has nothing to do with compromise. See, the statement made in the cross-examination will be subject to interpretation,
He has taken.
basing on the evidence, other evidences available on record. This cannot be a conclusive proof. Okay, we'll issue notice, but then we do not know. And think over. This court basically, you see, does not accept the compromise where the voluntariness remains a question. If complainant and the accused is represented by one counsel, then it remains hard. MS Riatam, MSP Riatam, Landed Counsel for the petitioner, issue notice, returnable in 3 weeks. Mr. Ranger, Landed GA accepts appears on behalf of the respondent, all the respondents.
All respond.
What you said, issue? No sponsor? Okay. Okay. It was sponsor, Mr. The learned GA shall obtain necessary instruction. Go to the next date. List after 3 weeks. But it's if there is a compromise, can it be accepted, or it has to be accepted, isn't it?
Lordship, there's similar.
Yes, similar. Even this court also has, because
Lordship,
there is a
recently-
decision by coordinate bench.
Lordship.
But then that is also, this court has doubt. You see, the
But then
problem
the
is
fact
that
remains in this case, my lord, in regards to the settlement, my lord. There's no.
we can understand, but then assuming there is a settlement, around these things, even there also remains doubt. We do not know, but then it seems like state is not at all interested in, you see, like basically challenging the decisions involving question of law and all. Nothing. And then how many times this court will disagree with the decision of coordinate benches? Think what, you know, state is mom on very serious things.
Team leave.
Daily Councillors, item number 1.
Yes.
My lord, may I please, Your Lordship? My lord, insofar as notice to the other remaining respondents, my lord, Dastik has been completed on the 13th of March. And to us, we have already served the copy.
When did you serve it?
To all the remaining respondents, my lord.
You have filed an affidavit.
No, my lord, I have not filed the
You
affidavit.
filed an affidavit in service, then we'll see. Yes. MSR Colony, London Council. You are appearing, Mr. Samay, you are appearing
What
for?
about the respondent number 1?
We have 6 respondents here, my lord.
Yes. There is some order passed, I think, before that. This will be considered after.
My lord, because here even the revision petitions are yet to be admitted, my lord. Even the revision petition is yet to be admitted. So the question of the pleading only will come
Oh,
on
there is the 227 matter.
My lord, yes.
And you are the plaintiff in the trial court.
Yes.
You have a. Are you challenging the maintainability?
My lord, yes.
Anyway, MSR Colony, London Council, for the petitioner submits that the respondent number 225 TO2. Okay. Have already been served by Justice Service. Stop. She prays for grant of some time to file an affidavit in support of the service. In support of the service of notice upon the state respondent. How long will it take?
My lord, I can file it within 2 to 3 days, my lord.
Just wait for list this matter after a week. Just wait for see here this if a matter is not admitted, you are not entitled to a petition. Are you if you have sought for this thing, becoming party, join us petitioner. We are on the issue 227, how it is maintainable. Just tell us what is the gross error of law committed. Of course, we should not ask you. You are yet to become a party. Anyway, let us file the service affidavit. What we just tell me. Yes, wait for 1 week's time is granted to the petitioner to file the affidavit of service. List accordingly. Yes.
My lord.
Item number 2.
After you become party, then only we'll ask you.
Look, in the meanwhile, Milords,
Yes.
because your lordship had indicated on the last date as to the effect of the order on MECL, Milords, we are proceeding with the construction activities because, as such, Milords, the order does not mention the name of MECL. Although that is yet to be argued, Milords, on the admissibility of the writ petition. But if your lordship can take it after 1 week, because there is certain deadline that we are facing.
See, deadline by whom? Who has given you deadline? Oh, for completion of the work.
Completion of the work.
And then who is disturbing your work?
Well, the disturbance is by the plaintiffs in the suit.
The plaintiff on the basis of the order passed in a matter where you are a party.
Yeah, where I have not been made a party.
Then how can the order be implemented against you?
Yes,
you know
yes,
law very well, Mr. Pandey. You know
Yes,
law very
Milords.
well, Mr. Pandey. In such a situation, what is to be done, you know it very well.
Yes,
227 will be concerned basically with the question of commission of gross error of law by the trial court. Nothing else.
Yes,
I mean,
yes.
say that this is my land, which has been basically, you see, like, it is my land which has been basically made involved in that suit. That this court cannot decide, and that cannot be a ground for filing 227.
Milords, we'll address the issue of how we are aggrieved after Milords, we file the affidavit of service.
Please enlighten this court.
Yes.
Yes.
Obliged.
7.
Continue.
Matter has become infactual as per my understanding, my lord,
Yes.
because there is a notification of his order dated order number 44 dated 19 September 2024, my lord,
Yes.
in which, my lord, they have said that 5th pay commission to make the salary slip, my lord, as per the 5th pay commission, and the prayer of the petitioner is to, my lord, implement 5th pay commission, my lord. So that suffice, my lord.
This is payment to salary for 1 month.
Yeah,
Yes,
on one
only
month.
one.
Once the 5th pay commission comes to for 1 month, my lord, it has to continue, my lord. It cannot be for a particular month, because
So
we are having.
we can record your submission.
Yes.
That is.
Yes, my lord, that can be recorded.
If that
But
is recorded, I have no objection, Lordship. Then it can be.
even if the submission is not recorded, it has to be implied, my lord. It cannot be for 1 month. We'll give 5th commission.
It's up to you, see, Mr. Whatever you say, this court will go by this.
Yes, my lord. We
Because it
are
is your
implementing, my
department.
lord.
You are the best person who will
Yes.
be.
My lord, that is the instruction that I have, my lord. That may be recorded.
Lordship.
No problem.
Lordship.
Yes. Mr. S. D. Lane, counsel, appearing for the respond number. Oh, you are appearing for both the.
For all the respondent, my lord.
Appearing for the respondents has placed on record. Has submitted that this writ petition has submitted that this writ petition because infectious in view of the fact that the grievances raised by the petitioner in this writ petition, or in view of the fact that the relief sought by the writ petitioners in this writ petition has already been granted to them by office order number
44,
right?
my lord.
Office order number
Office order number 44 dated 19
Yes,
September
yes.
2024.
You can get it from there. Number so and so issued by the Secretary Executive Committee GHDC Tura. You have received a copy of this.
I only have provided to
Mr. P.T. Sangma, Lade Council, appearing for the Mr. Petition Lade Council appearing for the petitioner points out that the order which is placed on record by the learned, which is placed on record by the learned counsel for the respondent, speaks of implementation of the recommendation of the Meghalaya 5th Pay Commission only for 1 month. Stop. And only for 1 month, and there is no indication that the same would be continued, and there is no indication that the recommendation has been accepted for regular payment of salary, on regular basis. Okay, stop. Mr. Day, on the other hand, submits that though the office order concerns with the payment of salary of 1 month, comma, as a matter of fact, the district council has taken a conscious decision to implement the recommendation of the Meghalaya 5th Pay Commission, and the benefit of the recommendation would be passed to the petitioner on regular basis.
Whenever, my lord, fund is available, my lord. The issue.
That is a different. We are not
Yes,
going to
we
a
will
fine.
He may come with a contempt, my
No,
lord,
no,
that we have to pay.
no, Lordship.
Benefit.
Let that be recorded, my lord.
No, that-
Just for my clarification, my
No,
lord.
it would
That should
mean
not be
it would mean that depending on the fine, you
Yes.
can vary the salary.
Yes, yes,
We are-
yes.
That
No,
will,
no.
it will have a say.
No, no. What
See,
we,
Mr.
That much
Dey,
enough, Lordship.
fine
Yes,
question is not
yes,
coming here
yes,
at
yes,
all.
Lordship.
no, because
is
my
only
lord,
for the-
my lord has recorded that we are going to pay the regular salaries, my lord. That, my lord.
No, will be benefit will be extended
Yes.
on regular.
Yes,
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 yes.
yes.
That is
Only-
what- that
yes.
is what we have.
My lord,
Yes,
my lord.
Lordship. That's enough.
Yes, sir. Your paragraph in view of the submission, in view of the categorical submission made by the non-net counsel for the respondent, it is apparent that no further order is called for in this writ petition. As the same has become, as the relief prayed for by the petitioner in this case has already been granted to them. The writ petition has, as such, has become infructuous and stands closed accordingly.
Hello.
Deeply beloved, my lord. Much blessed, Lordship.
Item number 8.
Lordship, there is a similar matter pending before the division bench, Lordship.
Yes, correct.
Yes, Lordship.
Then why you are having here? Then let the matter be decided. We can close that. This matter will be bound by the decision made in the matter pending before division bench. Can't it be closed that way? You are not very sure. There is any difference of prayer in this
Lordship.
case and the case.
There is a difference, Lordship.
What is the difference?
Here we are challenging the legality committed by the state respondent in avoiding the tender in favor of the private respondent number 5. And there we are challenging
And before the DV, what is the matter?
the entire
The rules by which.
policy of the government, Lordship.
So if the division bench matter is decided in your favor, that will decide this matter also.
Lordship.
And if it goes against you, then this will survive. This is the thing.
It goes against them, then the matter will survive. But it division bench decides in their favor, this
Okay.
renders infructuous.
Just you do one. Just see the last product. Just copy details. When shall we do?
Those are fixed on 26, 27, 28. 3 consecutive days.
Then write the Lana Council appearing for the parties.
First or second week of
We have it together. That matter will be disposed of on the next day. We'll have it after 3 or 4 weeks. Useless. You are making this unnecessary. We make this order sheet very thick, and the file becomes frightening. Yes, the Lana Council for the appearing of the parties submit that the connected matter pending before the division bench, having bearing in the present case, is yet to be disposed of. In view of the submission, this is matter after 3 weeks. 4 weeks. 4 weeks. After 4 weeks.
Lordship.
Yes.
Item number 10.
I'll pray for some time, my lord, in this matter today. This pertains to, my lord, whether the directors of a company are liable or not in a criminal prosecution under Drugs and Cosmetics Act, my lord. There's certain judgments, my lord, which I'll have to place.
Yes, probably recently some judgments.
Very
have come
recently, my lord, that one I want to place.
with regards to the directors
Yes,
and all.
yes.
Probably.
If they are not directly involved in the manufacturing process, ordinarily they are not liable for any criminal prosecution. That's the case.
Is it?
Yes.
Probably. Let us see.
Well, there are decisions which say, my lord, bouncing of check is one thing, my lord, because that is said in other respects.
So this the recent decisions are in the context of this thing bouncing off.
No, my lord, I believe there is one in relation to Drugs and Cosmetics Act also, my lord.
Okay.
Bouncing of check, it is a decided matter, my lord. That was decided, I think, last year also. Recent judgments are.
But in one of the High Court has said that, my lord, manufacturing of drugs it cannot be done with the fake manufacturing of drugs cannot be done without the consent or knowledge of the
That is the only judgment of Kerala High Court, I believe.
So that is the only issue involved.
That's the only issue.
Only issue involved.
Whether the director can be
vicariously-
implicated or not.
Vicarious
Vicariously
liability is there if whether the directors can be said to be involved in the if they are not said to be involved. My lord, what is the case here is that, my lord, pleadings have to be taken, specific allegations have to be made. Now suppose an allegation, a complaint is filed, just making an allegation just because that you are the director of a particular company, you are liable, because directors are not ordinarily involved in the manufacturing process. So that is the case here. Some judgments are there. I have
Under the Drugs and Cosmetics Acts,
my lord.
this how the cognizance of offence are taken?
Well, they file a complaint under section
Complaint case.
CR.
The police has no jurisdiction to
No
investigate.
police.
It's a complaint case.
They have their own investigation. They do their own investigation. After a report comes, then
These
thereafter.
are all non-cognizable offences.
My lord.
You have to enlighten the court.
My lord, I will.
Do not mislead.
I will. My lord.
But that reason, I think, is very enlightening reason also. Because High Court very clearly said, my lord, in normal cases like a check bounced, subordinate officer issued a check, the director may not be aware. But when the company is the basic activities of the company, where the drugs itself manufactured by the company do not meet the standards of drug,
Yes, because
drug
it is
control.
the main job of the company.
Main job of the company, and
The
then
director
directors
cannot plead ignorance of the thing that I do not know what is manufactured.
what is happening in my company.
I'll also place some judgments. That is the only High Court
quite
which is
logical.
Kerala High Court. Kerala.
This covers up the issue according to you.
According to us, it covers.
Yes, until and unless
I'll get something from the Supreme Court.
Mr. Gautam shows some judgment contrary to what you say.
No, that is the only High Court. Well, that is the only judgment where the High Court has said that managing directors are also liable. But other High Courts have taken a different view. As far as High Courts are concerned, Supreme Court, I'll just have to see whether there is any particular judgment with regards to drugs and cosmetics, which I believe there is.
Okay. Just at the request of the learned counsel or the petitioner, come on, not objected by the. You are appearing as DSGI here?
Yes.
No, private counsel.
No.
DSGI. Not objected by the learned.
I am appealing for the complainant, drug controller, the office of the drug controller who has filed the complaint. Well, I am appealing.
So you are representing DSGI, not
DSGI.
At the request of Mr. Request from the learned counsel division, not having any sir. Please this matter after 2 weeks.
Obliged.
Yes.
Obliged.